Hello, happy Friday, amazing people. Very excited to be back on here. Today, we're going to be discussing something exciting. We're going to be chatting about an immigrant story. We have an immigrant story, so stay with us, and then we're going to learn some lessons from this immigrant story. Okay, so we're live on um, the various social media channels: TikTok, Instagram, Facebook, YouTube, LinkedIn, Twitter. We're live on all these places. Okay, so let me just jump into it. I haven't been on here this week. I was recovering from my birthday celebration. So, and even as I sit here, I have a really crazy headache this afternoon. But I needed to share this story with you guys so that we can all learn some lessons out of it. So this immigrant story, let me see. Okay, I'm sharing my screen with all the channels apart from Instagram and TikTok. Okay. Let me scroll down a little bit. Okay. So this case actually happened in Accra, Ghana. Okay. And I'll give you the gist and then we'll go into the details of the case. So this concerned a gentleman and his wife. His wife had, taken part in the American visa lottery, and his wife had won the diversity visa lottery. This was all the way back in 2009. And for some reason, I believe the guy must have also participated by himself. He had also, taken part in the American visa lottery, and he had been rendered inadmissible. So even though his wife had won the American visa lottery, the husband was denied, the immigrant visa that would enable him to come to the US to begin his life as um let me take this off the main screen, and then once we're back to the case, I will open the case up. I'm sorry for that. Okay, so the guy was denied. His wife essentially won the visa lottery, had come to the US, and then he was a derivative of the wife's application. But it seems to me as though he had actually also probably done an application by himself, because the reason for the denial of his immigrant visa was that he had submitted a fake WAEC certificate that showed that I believe he had completed secondary school. So the certificate that he procured was fake. And of course, he was busted. They found out that this was fake, and then they slapped him with the misrepresentation bar. And that bar is a permanent bar that will prevent you forever from ever getting any type of visa to come to the US, unless and until you're able to file a waiver to waive that inadmissibility. Okay, so even though this case happened in Accra, Ghana, I believe the guy and his wife were both Nigerians. As to how, they probably were living in Ghana, and then they applied, and then that's what happened. This was back in 2009. So I believe at that time, Nigerians, there were certain years in the past where Nigerians were able to partake in the American visa lottery. So that's what happened. Okay. And then they filed a waiver. Nigerians never say die. So they wanted to challenge it. They hired a lawyer, and then they filed an appeal of the case. And so we're going to go into the case right now. Let me pull this up. You guys are going to learn some very nice lessons. We are all going to learn some very nice lessons, and then we can call it a day and enjoy our weekend. Okay, so again, this was an application for waiver of grounds of inadmissibility under the Immigration Nationality Act. Okay. Again, you see, guys, if you are applying for a visa or applying for a green card or trying to come into the US, the most common type of things that can get you a big bar are misrepresentation, lying, right? Oral misrepresentation, documentary misrepresentation. Misrepresentation just means that you're lying. Documentary fraud, which is also a type of misrepresentation, and then relationship fraud. Those are really common. And so you want to be careful of those things. Okay. So they filed an appeal of the guy's denial. Now let's go into the case right here. This waiver application was denied by the Field Office Director, Accra, Ghana. Again, these are, of course, the U.S. Embassy in Accra, Ghana. The applicant is a native and citizen of Nigeria. He was found inadmissible under the INA section 212A6CI. You hear me talk about that a lot. A lot of people get the INA 212A6CI. It's either, you either have a misrepresentation bar or you have a fraud bar. If you were able to deceive the officer, the immigration officer, then you have a fraud bar. If you were not able to deceive the immigration officer and you couldn't get a benefit out of it, then you get a misrepresentation bar because you were caught before the results. Okay, so so essentially, as I was telling you, he was a derivative beneficiary of the visa lottery, and he wanted to waive his inadmissibility. And the INA 212, that's where the waiver is codified in statute. And he wanted to waive it based on extreme hardship that would be caused to his wife. If, and his wife was a green card holder, if he wasn't allowed to enter, you can actually waive, again, these grounds of inadmissibility based on hardship that can be caused to certain qualifying relatives, okay? So they reviewed the case. The standard of review was de novo. They reviewed everything in its entirety. The entire record was reviewed. And then they pretty much started with the analysis. So if you are an alien, it means you are a non-US citizen, and if by fraud or willful misrepresentation, or you willfully misrepresent a material fact and you attempt to procure or you procure a US visa or any other type of U.S. immigration law benefits, then you are inadmissible. Again, inadmissible means that you will not be allowed to get a visa, you will not be allowed to get a green card until you waive that fraud or misrepresentation. Okay. So now they define what misrepresentation means in immigration law. It means that, they define materiality of a misrepresentation, because if it's a misrepresentation that is not material, then you don't get the bar, right? The misrepresentation must be material in nature. And what does this mean? It means that the alien or the non-citizen received the benefits for which he would not otherwise have been eligible. So that means that whatever you were misrepresenting or lying about must have been germane to the type of application or to the type of benefits you were seeking. So if you were seeking a visa and then you lied about the fact that you've had sex with 500 women, that's not germane to the visa application. But if you lie about the fact that you have a secondary school education, and let's say visa lottery, they're requiring a secondary school education certification, then that's material, because without that, you would not have gotten the visa. So the misrepresentation must be material in that it's because of the misrepresentation that you would have been eligible for the visa. Okay, so that's what happened. And note that normally derivatives of, for example, visa lottery, they are not required to show that they satisfy the eligibility grounds, right? It's the main applicant. So that's why I believe that he probably applied by himself, and then his wife won, and then he was also trying to come as a derivative. Okay, so I have a meeting very shortly, so we are going to run through the case law. Stick with me, stick with us, guys. You forgot, drop me your emojis. Let me know you guys are with me. Drop me your emojis. If the story is getting juicier, drop me your fire emoji or a tea emoji, okay? Teacup emoji. Let's move on. So the appeal, the counsel for the applicant was saying that, well, this thing was not material. The fact that he submitted a fraudulent WAEC certificate in support of his diversity visa application in 1998. Oh, okay. I now see what happened. So you see, guys, The guy himself applied for that diversity visa lottery in 98, so several years before his wife actually won the visa lottery. And the years he submitted, I believe 10 years ago in 98, he submitted a fake document and they found out, right? So that's why he was inadmissible. So again, one lesson, don't think that, oh, I submitted a document to the US Embassy 10 years ago or 15 years ago, so they don't remember. They keep track of everything, you see. So that was what he did. He, in support of his visa lottery, a fraudulent WAEC certificate, very unacceptable. So that's why he was inadmissible. And then the lawyer was arguing that, well, he submitted a fake certificate, but that document was not material to the guy, being eligible for the visa, diversity visa lottery, the diversity visa that he was seeking. And the appeal, the administrative, the appeal people said, listen, to enter the diversity visa lottery program, you must meet either the education or work experience requirement, meaning that the person must either have a high school certificate or its equivalent. And this is defined as a successful completion of a 12-year course of elementary, secondary education, or 2 years of work experience within the last 5 years in an occupation requiring at least 2 years of training to perform. Okay, so that shows that the guy trying to use the fake WAEC certificate, that fake WAEC certificate was material to that visa lottery he was applying for. And so the element of materiality of the misrepresentation had been met. For that matter, the guy was simply inadmissible. Okay, so let's keep it moving. In the instance case, the applicant used the fraudulent WAEC records to satisfy the education requirements of the diversity visa program. As such, the appeal administrative office finds that the use of a fraudulent WAEC document would be material to the applicant's eligibility for the visa slot, and he would, as a result, be inadmissible under Section 212A60I of the Immigration and Nationality Act. This, oh my God, these people are so funny, and I love the way that the lawyers, the judges even write their, they write their ruling. What they stated underneath it is that, as a result, we will not disturb the finding of inadmissibility. So you are expecting them to disturb this finding of inadmissibility. They're telling you that this finding is correct. It is accurate. They are not disturbing it. They will not touch it with a 10-foot pole. And so you are inadmissible. You are going to be stuck in the inadmissibility arena until something changes. Okay, so I just love that we will not disturb this finding of inadmissibility. So sorry. Okay, so first of all, they will now establish that, okay, was the guy truly inadmissible? If he was if you are inadmissible, now let's move on to the second stage. Is there anything I can do about my inadmissibility? Yes, there are things you can do about your inadmissibility. If it's for a non-immigrant visa, it's a greencard waiver. If it's for an immigrant visa, it's for this specific instance, it's a 601 waiver, I believe. Yes, a 601 waiver, because it was for misrepresentation. So the 601 waiver, again, has been codified under Section 212I of the Immigration and Nationality Act. And what it says is that the Attorney General may, in his discretion, he can waive the application of misrepresentation in the case of a non-citizen or an alien who is a spouse, son or daughter of a U.S. citizen or a green card holder. I've quoted it. I've restated the law, but just to make it understandable to all of us. Okay. So if it is established to the satisfaction of the Attorney General that the refusal of admission to the United States of such an immigrant will result in extreme hardship to the citizen or lawful or green card holder, spouse, or parent of such an alien. Okay, so simply put, if you have an inadmissibility, you can file a waiver. In order to file a waiver, you have to establish two things. Number one, that you have a qualifying relative. In this instance, you need either a wife or husband or a parent, right, who is a U.S. citizen or a green card holder. And you are telling the U.S. government or the U.S. government that, look, I know I made a mistake. I'm sorry I brought fake documents, but can you please forgive me? Can you waive this inadmissibility? Because if you don't let me come to America, there's going to be undue hardship to my qualifying relative. And undue hardship, the standard is extreme hardship. So there are different levels of standard. So for example, if you are doing a cancellation of removal, the standard is by unusual and extreme hardship. In a 601 waiver, the standard is just by extreme hardship. So it's a little bit lower, a tad lower than, a cancellation of removal hardship standard. Again, there are varying standards of inadmissibilities. Okay, so of waivers, I mean. So the next thing is, the guy was saying, okay, like I have a wife, she's in the US. If you don't let me come, she's going to experience extreme hardship. So here are some of the factors they will look at. They stated, the board stated, the appeal board stated that extreme hardship is not a definable term of fixed and inflexible content or meaning. This means that there's no one size fits all for extreme hardship. It doesn't mean that extreme hardship has to come in the form of sickness. No, it doesn't have to mean that extreme hardship will come in the form of only cancer, or extreme hardship will come in the form of sexual starvation. That's not extreme hardship, but just an example, right? Because that, it can be, it's flexible. Extreme hardship depends on who is involved, what are their personal circumstances, what type of hardship can befall them if their relative is not allowed to come to the US. So what they stated again was that the factors include, there are many factors they look at to see, okay, is there extreme hardship? Number one, they could take a look at, what are your ties? Let me see, okay, the conditions in the country to which the relative's family, I've highlighted my PDF too much, so now I can't even see properly. Okay, let me give a couple of examples. The factors include the presence of a lawful permanent resident or parent in this country, the qualifying relatives. Okay, so the qualifying relatives' family ties outside the US. That's relevant because if you're saying that you'll not allow the family member to come to the US, then probably the qualifying relative who's in the US, that would be the US citizen, let's say spouse or green card holder spouse, will now have to go back to Nigeria or Ghana. So you have to show, okay, what are the qualifying relatives, his ties back in Nigeria or Ghana? What are the conditions in the country to which the relatives ties, the qualifying, the conditions where he's supposed to go back to, the conditions of the country, Nigeria and Ghana. How bad are those conditions? Will extreme hardship be caused? What's the financial impact of the departure from the US? Right? And the significant conditions of health, particularly when tied to an unavailability of suitable medical care in the country to which the qualifying relative would relocate. So of course, it would mean that the qualifying relative has to go back to Ghana or Nigeria. So you discuss those types of things. Now the board has held that. So the thing is, a lot of people try to argue that, oh, if you don't give me the visa, extreme hardship will be caused to me. But they are not able to prove that this extreme hardship rises to the level, this hardship rises to the level of extremity. You see, common hardships are normal. Of course, being separated, yeah, you'll face pain, there's financial impacts, but according to the law, that's not extreme hardship. Okay, so you have to show extreme hardship. And what they said is that the board has also held that common or typical results of removal and inadmissibility do not constitute extreme hardship. Okay, so there are certain things that are considered common hardships and not extreme hardship. There is a fine distinction. So factors that are common hardships are like, economic disadvantage. Of course, if the guy doesn't come and join his wife, then there's going to be just one income. They can't make a lot of dollars, right? So that's economic hardship. It's not extreme. It's very common. Now, the second thing is economic hardship, loss of current employment, inability to maintain one's present standard of living, inability to pursue a chosen profession, separation from family members, severing community ties, cultural readjustments after living in the US for many years, cultural adjustments of qualifying relatives who have never lived outside the US, inferior economic and educational opportunities in the foreign country. So guys, they're trying to tell you that, look, if you want to prove extreme hardship, don't come and tell us about things about common hardships. These are common. You see, these are they feel like these are things that come with deportation and removal. So that's not the standard. You have to show extremity of the hardship. And normally, the factors are normally viewed in the aggregate. They are considered in the aggregate. This means that they will now add up all your hardship and see if it rises to the extreme level they are looking for. So, for example, let's say you have a son who's asthmatic. Let's say the green card holder wife with our case, the green card holder wife in the US has a son who's asthmatic, and he's like, look, if I come to Ghana, there's too much dust. It will trigger my son's hardship. That's the first hardship. It may not rise to the level of extremity, but that, along with other circumstances. So, for example, the second one could be maybe the woman herself has cancer, and then she's going chemotherapy, and she has insurance, and if she moves to Ghana or Nigeria, she may not be able to get the type of treatment and insurance. So that's the second type of hardship. Then you find a third hardship where maybe the guy has begun school and he's undergoing therapy because of some crazy issues that have happened to him. He almost committed suicide, and the type of therapy he's seeking and the type of help he's receiving, if he goes to Nigeria and Ghana, maybe he cannot get. So you see, these three factors in the aggregate must rise to the level of extremity. So they will consider the factors in the aggregate together to determine whether extreme hardship is present in your case. Okay. Alrighty. So yeah, they found that, look, this did not meet so they denied the guy the visa. The appeal was denied. And unfortunately also for him, yeah, let me tell you guys about this. The girl was saying that, look, hardship will be caused to her because she doesn't want to return to Nigeria. She's not able to return to Nigeria because she has serious family problems in Nigeria. She said her mother is dead and that her father doesn't like her. And the board were like, okay, your mother is dead. That's fine. Your father doesn't like you. How does that prove extreme hardship? If your father doesn't like you, they don't see how that should affect you moving back to Nigeria. So the appeal board did not buy that argument. They said it was a weak argument. Okay. The guy, okay, yeah. So what else? Well, we'll just skim over all these things. We don't need all these things. And yeah. The other thing was that you guys know that when you're applying for the American Visa Lottery, you usually need to be issued with a visa before the end of the fiscal year. In this particular case, the fiscal year for the visa lottery was 2009, so they should have been issued a visa by 30th September 2009, but it was beyond that time. So the board was like, look, in any case, we are not even going to issue the visa because you cannot be issued with a visa under the diversity visa lottery program. So he was denied. Okay, and then finally we can talk about these two things. The board said that in the aggregate, in this, let's look at the final, how the board concluded. They said, in this case, even where the applicant to be eligible for an immigrant visa, let me see if the Facebookers see me because I haven't even checked. Okay. Oh, good. I think they can hear me. I see all the good vibes on Facebook. I'll read comments soon. Guys, bear with me. The board said, in this case, even where the applicant to be eligible for an immigrant visa, the record does not contain sufficient evidence to show that the hardships faced by the qualifying relative considered in the aggregate rise beyond the common results of removal or inadmissibility to the level of extreme hardship. They find that he failed to establish extreme hardship as required, and so they denied it. And then the last thing was that again, they reiterated what the standard, the burden of proof is, what the standard of proof is. They said that if you are trying to apply for a waiver, then the burden of proving eligibility remains entirely with you, the applicant. So if you don't meet that burden, you're going to be denied. This is what I've been telling you guys about. So they said the guy did not meet the burden, and so case denied. There's just a lot of lessons out of this. Again, waivers are very hard to win, especially if you don't have extreme, things, you're not able to prove your case as is required of you. So I hope you guys have enjoyed this immigrant story. Unfortunately, our friend from Nigeria, who I believe was based in Ghana, was denied his immigrant visa because he submitted a fake or fraudulent WAEC certificate. Okay, so that's it. Let me read a few comments from YouTube and Facebook. So this is from YouTube. Amwaba Derek says, good evening, dear. Hello. Brother Isaac on YouTube says, good evening, sister. Hi. Kiki Keel says, good vibes. Okay. Thank you for sharing your good vibes. And then Ikuya Chewa is giving us a fire emoji. Abrantepa. Let me scroll down a little bit. Abrantepa tuya hene. Abrantep. Okay, for some reason, Abrantepa tuya hene's comment is not showing. He's giving us a fire emoji on Facebook. Oh, Ikuya is on in LinkedIn. Ikuya Chewa. Thanks for joining, guys. And then we have David Harrison, who is also dropping some fire emojis. So that's wonderful. Thank you, guys. Let me now. Okay, now let's see. Zoe Stan Apparels on Instagram says, "You are so beautiful. Thank you. Thank you very much. I really appreciate it. That's very kind of you." Essence Golden on Instagram says, "Hello, beautiful. Hi. Hi there." Ama Fresh said, Nigerians never they carry last. Abuna Sugar Trust says, this person gets vim. Oh. People really get vim. Okay. Ama Fresh said, USCIS always finds everything out. Never lie. That's very correct. That's very correct. Okay, so we have all these nice comments. B Nikwe says, in the case where the applicant didn't complete junior high school, but now a mechanical has a required experience, please go on to onet.online. And then you should be able to enter that in. Please, can you educate us on the visa lottery? Ray Looney. Guys, we have discussed the visa lottery very extensively several times. The deadline is almost up by November 8th. Today is 4th. So you guys have 4 days. If you haven't yet signed up, if you want to sign up, don't forget to do so. Karishma says, I've applied for my I-751, haven't heard back. Anything add yet? Yeah, I-751s take a long time investigation. So you can get a very fast adjudication, but it doesn't always happen. It just depends on how you prepared your application. Bushra Nafis on TikTok says, can I add my husband's bank statement and his earning if I can't find a sponsor? You need a consult for this. It depends. Is your husband the intending immigrant or you are? You need to, please consult me. Let me check it to see if you're making enough money. If you're not, I'll be able to advise you, because the joint sponsor has to be eligible to be a joint sponsor. So that's something we need to review. Okay. Alrighty. Let me see what else on TikTok. Can someone who has a B1, B2 visa still apply for the DV lottery? Again, you absolutely can. But remember, if once you get to the port of entry, if they put you in secondary inspection and then they find out that you applied for the visa lottery, and then they also suspect that you're trying to come in and never leave, then there could be a problem. So, you should be able to demonstrate that, you were just trying your luck, and you really, at each point in time when you're using a B1, B2 visa, you should always be able to show them that you're coming in for a temporary period. So try to have a lot of evidence on you, like, okay, you just took a leave from work, you took leave from work, you still have you are paying rent in your home country, you have a lot of ties to your home country. That will help you. And then avoid having things on WhatsApp like you are searching for jobs in New York and things like that when you're coming in on a B2 visa, because they will inspect these things, and if they find that what they find matches up with the fact that you applied for the visa lottery, then they will put you in expedited removal, cancel your visa. Okay, guys. Hello, please, if a guy in Ghana marries a US citizen, how can you move from here to what are the steps to take before and after the marriage? Kwesi Ahiale, please contact me and then I'll try to help you. But basically, the steps are that they have to file a petition for you. If you're married to a U.S. citizen, they have to start. It's a two-part process. First process, they file the petition, moves to the NVC, then it moves to the U.S. Embassy. But schedule a consult, and then I can guide you guys through the process. Okay, guys, I have to run now. I hope you guys have enjoyed this live session. I had to come your way at least this week. Oh, Theophilus Mantu on LinkedIn said, please, I just joined. Can you brief me? You can do a replay. Hopefully you can see what we spoke about. And then Idrisu says, please, can you apply for visa lottery when you're traveling to another country for a 2 years contract? Sure, why not? You can. All right, guys, thanks a lot for joining. Don't forget to share this video so that immigrants around the world can find us, especially if they need help with U.S. immigration law matters. Don't forget to like the page. Don't forget to give us a thumbs up, subscribe, comments, drop your emojis, and then I'll see you guys in the next video. If you're watching on Facebook or any other medium, please hit the like button. Hit it. All right, guys. Bye. Have a wonderful weekend. I'll see you guys soon. Take care. Bye, TikTokers. See ya.